Okay, Madhusrava,
Good morning, sir.
good morning. It is our second meeting. Okay, now probably you are prepared to face the viva of the judicial service examination. Anyhow, to refresh your memory, certain questions are asked. What
Yes,
is
sir.
judicial separation?
Sir, judicial separation is a order that is granted by a court to the spouses who do not want to take divorce right away. That's why before divorce is granted, a order of judicial separation may be passed where the marriage is not irretrievably broken down. In that case, to give the parties to a marriage a cooling off period, sort of order of judicial separation is passed.
Whether court can so moto pass the judicial separation decree, even it has not been applied.
Sir, in divorce proceedings or other that kind of proceedings, court can, instead of granting divorce, can so moto pass a decree of judicial separation.
What is irretrievable broken?
Irretrievable
Like
breakdown of marriage
you
is
told,
when. Sorry, sir.
you answered that irretrievable broken. That's your one of the answer. Whether on irretrievable broken ground judicial separation is to be given.
Irretrievable breakdown of marriage is not recognized as a ground under the act. However, the Supreme Court has time and again granted uh, judicial separation and as well as divorce in many cases on this ground, sir. It
But this,
means that the relationships between the parties have become so strained that it is no longer possible for them to cohabit and perform their marital obligations. So, in that case, the court grants divorce and separation also in some cases.
the judicial separation decree can be given when there is an irretrievable broken. That you mean to say?
Sir, when there is a no judicial separation is granted before that stage is reached. When irritable breakdown of marriage is there, then divorce is given. Before that, if the court is of the opinion that a cooling off period between the parties might benefit them, then in that case, judicial separation is granted.
Whether the family judge, now the almost all districts has family judges, family courts. Instead of districts, family judges, family courts are there. Whether the judge family court can is permitted to grant divorce on the ground that marriage is irretrievably broken.
No, sir. That is something that is usually done by the Supreme Court. In fact, the Supreme Court has cautioned that High Courts should also not grant divorce on that ground. It is something that is only done by the Supreme Court by exercise of its extraordinary powers.
What is divorce by mutual consent?
Divorce by mutual consent is when both the parties are not in an adversarial position and therefore approach the court that they do not want to no longer want to stay in the cohabit with each other and perform their marital obligations. So they may mutually agree and then approach the court to pass a decree of divorce on the basis of that agreement, sir.
What material facts, what facts are to be pleaded in the divorce petition by mutual consent?
There are many grounds on which uh, they can ask for divorce by mutual consent. And
Many grounds. What are the,
sorry,
can you
sir.
say one of the ground? Many grounds you say. Can you say one of the ground?
Uh, I'm unable to recall the grounds right now, sir.
Can a suit be filed by a minor before a court?
Yes, sir, a suit can be filed with the help of his next guardian. Next friend or legal guardian.
Next friend. Suppose without next friend, the minor, somebody files a petition that a suit, that a minor files a suit without being represented by a next friend. What will be the consequence?
The consequence will be that the court will direct that a legal guardian or next friend be with his consent, of course, included in the matter so that he can represent the minor in that way.
Can a suit be withdrawn?
Yes, sir, a suit may be withdrawn
When
with
a
the
suit is
permission
to be,
of the court.
then when a suit is to be, court will permit for withdrawal a suit with liberty to file a fresh suit.
If there is any formal defect in the suit, or in that case, the court can allow that the suit may be withdrawn and it can be put up as a fresh suit later.
Only on formal defect. Or is
No,
there any other one?
along with formal defect, if there is any other reason which is embarrassing the process of the court, in that case also.
What is the second appeal?
Second appeal is an appeal from a decree which is passed by the exercise of appellate powers.
Response.
Sorry, sir, could not hear what you.
Only second appeal. Where it is to be filed?
Second appeal is to be filed before the High Court, and it is restricted to matters of substantial questions of law, and it is on those grounds it is raised before the High Court.
When temporary injunction is to be issued in a suit?
Temporary injunction is granted in a suit where, in order to mostly to preserve the status quo of the parties. If, for instance, there is a property and anything that is being done with the intention of uh, depriving the parties in the litigation, the other party, from realizing the actual outcome of the case, or if he's transferring the property with the intention of defrauding the other party, or if any kind of uh, any kind of irreparable damage will be caused to the party to the suit, then in such cases temporary injunction is granted so that the property in dispute may be preserved, or any kind of a status quo that has to be maintained between the parties.
Only for maintaining status quo, the temporary injunction is issued. That you mean to say?
Mostly, yes, sir, that is the principle, so that nothing is changed and the litigation does not become infructuous because the matter itself, in dispute itself, is compromised.
What do you mean by status quo?
Status quo is the situation of both the parties as that they have come before the court, the way that they're situated.
If one of the party against whom a temporary injunction order has been issued, he violates that order, what action the other side will take in such case to implement that order of injunction?
So penalty is prescribed under the code.
What is that penalty?
I'm unable to recall that right now, sir.
When a court appoints a receiver
will appoint a receiver when it is of the opinion that neither of the parties should remain in charge of dealing with the property. So, a receiver is appointed to take care of the matters related to the property, like collecting the rent or any profits that are accruing in the property. So, in such a case, a receiver is appointed. Appointment, and it means that when a receiver is appointed, it means that the property has now become custodial aegis, uh, and any party who previously had the charge of the property will now be deprived of it, and appointing a receiver will mean that anything that if the court intends that anything that is collected from the property should be now equally distributed between the parties, or the rents and profit should be collected till the final outcome of the matter is decided. So in that case, a receiver is appointed.
What is the inherent power of the civil court?
Inherent power of the Supreme Court is of very wide nature. It
Civil
can
court. I
pass
represent
any.
civil court. Inherent power of a civil court, not Supreme Court.
Sorry, sir. Inherent power of a civil court is to pass any order or to take any kind of action which is not specifically provided by the by the civil code. These are mostly the powers of the high court when they were established by the letters patent, and now those powers are retained by the high courts, and they are called as inherent powers when there is no provision to fall back on in such cases to secure the ends of justice and to give full effect to any kind of order or decision. Inherent powers of the court are invoked.
When a major girl can claim maintenance from the father as per section 125 of the CRPC.
A major girl, as per section 125, cannot claim maintenance from the father unless such a major child is due to any reason of physical or mental disability, unable to take care of themselves and sustain themselves. In such cases, sir, maintenance may be granted to her under section 125 CRPC.
Is there any limit for giving maintenance amount under section 125 of the CRPC?
No, sir. Currently, there is no limit for giving maintenance under section 125 CRPC. Earlier, there was a limit of rupees 500, but now it has been removed by the 2001 amendment.
The order of maintenance was disobeyed. That was not obeyed. No maintenance amount was paid. What will be the consequence? What penalty is prescribed for the enforcement of that order?
For the enforcement of that order, even imprisonment may be ordered up to 1 month, if I'm not wrong.
For entire order?
Sorry, sir?
For the entire order, only maximum 1 month.
1 month at a time, sir.
At a time.
And if after that also it is not obeyed, then again for 1 month it may be imprisonment may be ordered.
What is set off of the sentence of imprisonment?
Set up? Sorry, sir?
Of the set off of imprisonment. Set up of the sentence of imprisonment. Set off from the sentence of imprisonment.
Sir, a set off of imprisonment is done in cases where a person has already undergone a period of imprisonment as a under trial prisoner. So in that case, whatever detention that he has already gone through may be set off with the final imprisonment that he's sentenced with.
What is admission? under the Evidence Act?
Admission is any kind of statement that is made by a party or his representative under the circumstances that are given under the act.
Whether admission is conclusive evidence?
No, sir, admission is not conclusive evidence. The court may call for proof despite some kind of admission also.
What is public document?
Public document is defined in Indian Evidence Act as any kind of record or act of the record of any official body like the legislature or the state legislature or the parliament or the courts or any foreign body also in the same kind of like a foreign government, and any private document which is recorded and stored in a public way is also as a public document is also a public document.
What recorded and stored? What is that? What do you mean by recorded and stored? Where?
Recorded in the sense if there's a agreement, it is there's a sale or deed or something which is a private, it is made between two private parties. But if it is officially registered in a designated register where they are supposed to be entered, and maybe a identification or registration number is given to them, then we can say that it is recorded and available for public scrutiny. So in that case, a private document, the record of a private document is a public document.
What is constructive notice under the Transfer of Property Act?
I'm sorry, I'm unable to answer that question, sir.
What is doctrine of lispendence?
Doctrine of lispendence, sir, is when a matter is pending before a court, then the subject matter of that dispute which is pending before the court should not be dealt with by the parties. And if it is at all dealt with, if there is any kind of transfer, then in that case, the rights of the party under that transfer will depend on the final decision of the court where the matter is pending.
What do you mean by subject matter of the suit?
Subject matter is any immovable property, sir. If there's any.
What is charged under the Transfer of Property Act?
I'm unable to say it as per the definition in the act, but from my understanding, sir, charge is when a right is created with respect to a immovable property in favor of a person who may not be the transferor or the transferee in the case, and that person has a right to get some kind of benefit out of that property. That in that case, for example, a property is transferred, and the order of maintenance is there, and that divorced wife, for instance, is entitled to get the money out of whatever benefit is accruing to the property. So in that case, we'll call it a charge.
What is redemption of a mortgage?
Redemption of a mortgage, sir, is when the mortgage debt is fully paid off, and the whatever rights that were vested in the mortgagee will now vest in whoever is redeeming the mortgage.
What is fact in issue?
Fact in issue, sir, is the principal fact, or the factum probandum, that that on whose basis any right or liability is asserted by a party in the matter.
What is attestation of a document? Attested. What do you mean by word attested as used in Transfer of Property Act?
Attestation is when a document is executed by the parties to the document, and then it is signed by one or two witnesses who have seen the document being executed by whoever purports to have executed that document.
Only seen somebody has seen somebody executing a document is to be treated as attesting witness.
If he has signed that as a attestator.
What is the purpose of attestation of a document execution?
I'm sorry, sir, I don't know.
Is there any document which requires compulsory attestation by witnesses?
I'm sorry, sir, I'm unable to answer that.
What is a primary evidence?
Primary evidence is the primary evidence is any kind of evidence which is itself produced before the court for inspection and admission, is a primary evidence.
What itself is produced?
The document, sir, if any evidence of a document is being given and the original document itself is being produced before the court, then we'll say that it is primary evidence of the document.
What is estoppel?
Estoppel is when one party, by his conduct or representation, leads another party to believe in something and act on the basis of that belief. It is called estoppel, because this person will then not be allowed to later deny such a act or representation on his part.
What is a declaratory suit?
Declaratory suit is filed under the Specific Relief Act to obtain any obtain from the court a decree declaring, positively affirming the rights that the person is claiming in the suit.
What is injunction? What is injunction?
Injunction is an order of the court by which the party against whom it is issued can be stopped from continuing some kind of act, or even to mandate some kind of act on his part. Then it is called injunction.
What is your view on the Uniform Civil Code, which is there is a proposal for codification of Uniform Civil Code? What is your view?
Yes, sir. Sir, in my view, it is a welcome step. It is something that we have that has been in discussion for ever since the constitution has come into force, and because India is such a diverse country with diverse sets of people, and there are so many laws, especially in the personal law area, which lead to tussle and confusion in certain cases. So, in my view, the Uniform Civil Code will streamline the legal process relating to many matters, and will this will somehow have the effect of uh, opening doors to less. There won't be as much litigation, because the process will be streamlined and uniform for everyone, and matters like matters of divorce and all those where we have seen litigation, because there is a difference of differential treatment towards different people, so that will also be reduced. And I think it's a welcome move, sir.
What do you mean by dowry?
Dowry, sir, is any kind of payment or gift or gratification that is demanded in lieu of marriage or in connection with marriage.
Only in lieu of marriage. But the
No, sir,
dower
in
is a dowry.
connection with marriage.
But the dower which is paid to a Mohammedan woman at the time of marriage, is it dowry?
No, sir, dower is not dowry. Dower is a mark of respect, and it does not fall under the definition of dowry. It has uh, been laid down in the act itself.
Suppose a woman offers to marry a man, a young girl offered to marry a young boy, that on the condition that or offering 10 lakh rupees to him. I will give you 10 lakh rupees, you please marry me. Is it a dowry?
No, sir.
Why?
Uh, Sir, because dowry law is not gender neutral, sir.
General interest. Thank you.
Gender
I will
neutral.
give you this. It is gender neutral.
It is gender neutral.
What do you mean by gender neutral?
Gender neutral means it applies to both men and women. That both men and women can be offenders under that law.
Okay. Anyhow, I will give my feedback after your interview by second panelist. Thank you.
Thank you, sir.
Shaba, good morning. Uh,
Good morning, sir.
I saw your CV, and it's a locus classicus for going to corporate world. Why do you want to join judiciary?
Sir, if you're basing that inference on the fact that I have done my master's in corporate law, I would like to tell you that it was not an active choice. I sat for CLAT, and the college that I got allotted had in their brochures the option of opting for constitutional law, and that is what I wanted. So I applied for that. But because it was Corona time and they could not go through with the recruitment of required professors to teach that subject, I was allotted corporate law and I had to go through with it. I could not withdraw at the last moment. I had always intended to sit for judicial services exam, sir.
Okay, but why that as well? Because as I can see, you have family who are advocates, so you must be having an established chamber. Then why not go for practice or core litigation as such, and go for judiciary where you will be posted at remote places like Malkangiri, Koraput, and probably you'll waste your career there.
So actually, I also have a family member in the judicial services, and she is a lady. So I've been more inspired by her than the person who is an advocate. I've always seen how dignified her job is and the power that she commands, and that has drawn me more towards her side of the profession than being assured by the fact that I'm a second generation lawyer and there's an established chamber. I would like to take that challenge.
Okay, okay. Uh, Can you tell me what is the difference between a human right and a fundamental right?
Fundamental right is given to the citizens and non-citizens also, as laid down in the Constitution of India. Human rights as such are not codified or enumerated anywhere. They are inherent and essential to the human condition. So, and recognized internationally also. So that's why. So that is the difference between human rights and fundamental rights. And there's
Okay.
a if I may continue.
Yes, yes, sure. Tell me.
Yes, as I was saying, fundamental rights are enforceable and vigorously guarded by the Constitution itself, and there are many recourses directly to the Supreme Court and the High Court as well in case of any violation of a fundamental right.
Do you agree with this proposition that criminal courts also have inherent powers?
Criminal courts, unlike in civil law, where even the lower courts have some inherent powers, criminal courts do not have. But since a high court is also included as a criminal court, it does have
No,
powers.
I'm saying lower court, not including a high court. Whether they have any inherent power.
Lower courts do not have any inherent powers, sir, in
What do you
criminal court.
understand by inherent power for that matter?
Inherent power is something that the power that exists without being granted by any kind of act of legislature.
So then the criminal courts need not do not need any statute to recognize that power, right? They have that power. What makes you think that they don't have that power?
No, so the power to act in a certain way or pass certain orders. In case of criminal law, especially, though there is judicial discretion because it is penal in nature, the discretion is hugely tempered, and one cannot just do what one wishes to do. So that is why lower criminal courts do not have the power, and there is a hierarchy and there's a strict following of that hierarchy in case of criminal courts. So they do not have inherent powers to go beyond the civil procedure code or any other law under which a set procedure is given to them. So if at all there is a vacuum in the law and they do not, there is no procedure given, then they cannot inherently draw upon their own powers to pass an order that goes beyond what is contained in the code of the act.
Okay, I'll give you an example to that respect. Tell me what should the court do? What should the court below do? Okay, I'll give you the exact case. There is a court which is having two records. One is a GR case which is having the number 123 of 2020, 123 of 2020, and there is another case pending in the same court which is special GR case of 123 of 2020. So the only differential factor being the special. Rest the numerology is same. So now an accused, and eventually what happened is that the accused persons are also the same in both the cases. I mean, the name of the accused persons are same in both the cases. So now there is a bail granted by the Honorable High Court in special GR case number 123 of 2023, and the advocate puts that bail order before the Honorable Court. And by mistake, instead of putting special GR case number 123 of 2023, GR case number 123 of 2023 is put. And the wrong accused, who should not have been released, has now been released on bail. And the person who should have been released, he is in wrongful detention. So do you think this vacuum, which has not been predicted by the CRPC as such, the court concerned is powerless to recall the release order, or it has to wait till High Court passes an order? What do you think? What should the court do? Because as per your logic, the court is helpless. The court cannot do anything. It has to wait it out. When the person who shouldn't be released has in fact been released, and the person who should be released, he is inside the custody. And this CRPC clearly did not predict. That's why there is no law to that effect in CRPC as well.
Yes, sir. I can understand what you're saying. There is actually no exact law to rectify such a situation. But I wonder if there's if creative interpretation of the already given provisions may be done to rectify such a situation. For instance, the Sessions Court has very wide powers in respect of bail under Section 439. So, if in such a case, if the Sessions could be approached to cancel such a bail, because they have wide powers under 439 to recall any
But then
accused who
you
believes
yourself
and
had
come out of
granted
the
the bill.
custody.
But then you yourself had granted the bill. Why would you ask him to cancel? Because he is obeying, and the bail should be cancelled only when he is violating one of the conditions. He is not violating any condition. The only remedy here is either to exercise the inherent power and recall that bail order. Otherwise, there is no other way you can address this. So, by virtue of that, I mean to ask whether there is any inherent power, because you gave the answer yourself that inherent powers are the powers which are there in the court themselves, not because of any statute, but because it is a court. So anyway, I got your point. Okay, so you're saying that because 482 does not say so, that's why criminal courts have no inherent power. That's all. Okay, okay. Can you tell me whether a warrant case can be converted into a summons case?
No, sir.
What do you understand by doctrine of Cyprus?
I'm unable to recall that at this point, sir.
Okay, okay. Get out of that inherent power zone. Come back to other questions. Okay, maybe you are stuck at that zone. Okay. Uh, Coming to, what is the effect of delay in holding a TI parade?
The delay has to be seen subjectively. If the delay has caused such a situation where it has the delay has been so long that the memory of the persons who are supposed to be identifying must have been must have faded by now, or if the delay has risked exposure of the accused to the persons who are supposed to be identifying, then in that case the delay would be fatal and the TIP would be pointless in such a case.
What is the difference between a constitution and constitutionalism?
Constitution, sir, is the living embodied document itself. Constitutionalism is the I'm sorry, what constitutionalism? I'm not able to say that.
Okay, okay. Uh, can you tell me whether after trial has commenced, amendment of a plaint can be done?
Yes, sir. Amendment may be done.
In what case? What has to satisfy? What he has to satisfy?
If there is material change in circumstances or any new evidence has come up which is absolutely necessary to the determination of the matter in hand, then in that case the court may allow amendment. Or if the court itself has uh, uh, struck out or added any new defendants, in that case also amendment of plaint may be done.
What is the difference between attempt and preparation? How do you really distinguish between the two? Because there is a clear overlapping between the two.
Yes, sir. I agree that there is a thin line between what amounts to preparation and what amounts to attempt. Preparation is mostly in the stage where the intention has manifested in small making arrangements or conduct that can lead to an actual step towards the commission of the offense. So when there is a point where, by the doctrine of locus poenitentiae, when there is a point where you can come back, when you can change your mind with respect to your act towards the actual commission of the offense, then we are still at the stage of preparation. But when something that is done, which need not always be the penultimate act, but when something has been done which takes the matter out of the hands of the person who is acting, and for instance the commission is prevented by the act of a third party, but anything that could be done by the actor itself has been done, then in that case we'll say that an attempt was made, because there is now no point of return from there.
Do you understand by Hicklin's test? Hicklin's test?
I'm not aware of that, sir. I'm so sorry.
Okay. What is the difference between a prescribed period and period of limitation?
Period of limitation is what is laid down in the Limitation Act, the years that are in the schedule. Prescribed period is the period that is calculated after taking into account all the other provisions of the Act where relaxations are granted.
Can prescribed period and period of limitation be same in a case?
Yeah, yes, sir. If there is such a matter where it does not fall under any of the provisions of the Limitation Act where it grants any relaxation or anything, then in that case it may be.
That I know, but I'm telling you, can there be a case when there can be no exception and exclusions under section 4 to 24? There can be no exception and exclusion whatsoever.
Seems difficult, sir, for that to actually happen in practicality.
Okay. Okay. Who is the father of CPC?
I'm unable to recall the name, sir.
What is a white collar crime?
Uh, White collar, I don't know the exact definition, sir, but from my understanding, white collar crimes are crimes that are mostly made so by statutes. They are what should I say? Like there's a concept of mala in say so and something that is prohibited. So if if certain acts are prohibited by certain statutes, then maybe they are white collar crimes.
Okay. Okay. Uh, can you tell me what was the fuss about in Citizenship Amendment Act? Why was such hue and cry over it?
Citizenship Amendment Act. I think it. I'm unable to recall that particular controversy right now. I'm sorry.
Okay. Okay. What is a production warrant?
Production warrant is when a warrant is passed for producing any kind of document or evidence that is in the power of some person. In that case, such a warrant may be issued.
You're saying, or just generally you are opining because of the name?
No, a production warrant, I think, is passed in such cases. Actually, I'm
Okay.
a little confused. I'm sorry, sir.
Okay, no issues. My last question is, what is the difference between a memorandum of association and an article of association?
I don't know, sir.
Okay. Thank you, Madhushraba. I'll give you feedback after Sir gives the feedback.
Okay, thank you, sir.
Yes, Madhusrava, you try to answer all the questions. Thereby you commit mistake. If you do not clear on a particular, or if your concept is not clear, never answer. Thereby it is not expected that everybody knows all answers, all laws. Laws is a very vast thing, it is very difficult. But some concept, you should have some concept. My first question was what is judicial separation? You say irrevocable broken. Why that was that term you brought? Why? What is that? Judicial separation means when a diverse proceeding is pending, the court, instead of granting divorce, may pass a decree for judicial separation. Only in a divorce 13A, divorce petition is pending, divorce proceeding is pending, or in a divorce proceeding, while without passing a divorce decree, the court may pass a decree for judicial separation, keeping the marriage alive. Marriage is not dissolved thereby. Parties are allowed to live separately. except in 13(1), that is, there is a provision that is ceased to be Hindu who is not heard for certain period. Three restrictions are there. In such case, judicial separation decree will not be passed. In 13(1) VI. Other than that, so your concept is not clear. What is judicial separation? That is petition for divorce was filed. The court, if court grants a divorce decree, that marriage is dissolved. Without dissolving the marriage, the court may in a proper. What is the case? That is up to the court. Discretion is of the court. Instead of granting dissolving marriage by a decree of divorce, the court may grant a decree of judicial separation. Then let them live separately, leaving the scope for them to reconcile their matrimonial dispute and live together. And any party may also file petition to, that is, set aside that decree if they are, that is, resolve their matrimonial dispute. Irretrievable broken, that is only a Supreme Court can grant. Unnecessary you brought this irretrievable to the notice of the panelist. Then divorce by mutual consent. On the other day, perhaps I have to inform you the answer. Divorce by mutual consent means what? Both husband and wife, they may file, a Hindu husband and wife, they may file a petition for dissolution of their marriage by a decree of, by a divorce, by their mutual consent. How? In such case, they are living separately, mentioning in the petition, they are living separately for 1 year and more. They are unable to live together and they have mutually agreed to dissolve their marriage by a decree. On these grounds, they can file a petition. Then the court, not earlier than 6 months and not later than 18 months, that period is there. If the court is satisfied that the petition is not collusive, then the court may dissolve their marriage by a decree of divorce on mutual consent. That you. Then minor may file a petition, complaint only through next friend. When a suit is filed by a minor without next friend, the defendant may file a petition to take back the plaint with a cost to be paid to him. That is the only provision where cost can be imposed against the advocate who filed that suit without the recommendation, either any party or the advocate. That you should remember. Under Order 32, such a provision is there. Advocate pays cost. Only a provision. Withdrawal of a suit, or with liberty to file a suit, when the court will fail, the suit will fail. The suit may fail, may proper word, the suit may fail due to some formal defects, or there are sufficient grounds. The court, for such giving such withdrawal, the court may permit the plaintiff to withdraw the suit with liberty to file fresh suit. These two grounds are there. Second appeal is filed after the challenging the judgment of the first appellate court before the High Court, only on the question of law. Only on the question of law. Court will frame, before admitting that second appeal, the High Court will frame the substantial, utter the substantial question of law, then admit. So for a facts, issue on facts, that will normally, that is not taken up, but a particular issue has been perversely decided. With some evidence are there, but that was not taken. In such case, High Court may also decide an issue on fact. Evidence is not purpose. That would say. Temporary injunction, not for preserve. Status quo means the property as it is to be maintained. My question was temporary injunction. Injunction directing a person do or not do something. In temporary injunction is issued when to prevent destruction, damage of the property, or to prevent somebody to be dispossessed of that property. For that, three factors are to be taken into consideration. What is that? That is prima facie case, balance of inconvenience, and irreparable loss. Prima facie case means arguable case, a good case. Inconvenient, balance of inconvenience. Inconvenience which will be caused if the injunction is granted, that is balance. Irreparable loss means the loss the party will be dispossessed, the party will sustain, that cannot be compensated by. These factors are taken into consideration. That is temporary injunction. Status quo is always that property must remain as it is. Status quo is never only property. Violation of injunction order. When injunction order is violated, that the party violating the injunction may be sent to civil prison or his property may be attached. Such a provision is there. Then receiver, when it is just and convenient, the court may appoint a receiver. That is what is it is mentioned. Under 40 just and convenient. What is just and convenient? That is to be considered. That is to be decided considering the facts and circumstances of each case. Separate. Just and convenient. Inherent power, section 151 of the CPC gives this inherent power to the civil court. Nothing contained in the civil procedure will prevent the court to pass any order, the ends of justice, or to prevent the abuse of possession. These two. This is inherent power. Then major guilt, yes, you are right in this question. Major guilt only unable to maintain because of bodily infirmity, or mental incapacity, mental defect, mental disorder. Then limit of maintenance of it is not there. Enforcement of maintenance, that you committed error. That for each month's maintenance, 1 month's sentence is. But failure to pay maintenance of each month is liable for sentence of 1, not as a whole, for entire month. Then set up of sentence for an under trial prisoner. If a person has been detained, previously he has been detained as an under trial prisoner, thereafter he is sentenced with imprisonment. The period for which he has been detained or he was detained as under trial prisoner, that will be set up against his sentence. That is set up. Then attested. Attested also, you should know. Attested by two or more witnesses who have seen the executant signing the document or who have received acknowledgement for the executant that he has signed that document. And each of such witness must sign in presence of the executant. Witness must sign in presence of the executant. Then that is valid attestation. The purpose of attestation is to authenticity of the execution. So that is, somebody has actually signed true execution to prove that it is true. Compulsory attestation, attested document, will, mortgage other than equitable mortgage. These are compulsory attestation when the mortgage is secured more than 100. Primary evidence means the document itself, that you are correct, document itself produced for the inspection of the court, that is called primary evidence. Estoppel. The other day I have told you, a person by his act, declaration, and omission, three things. Act, declaration, or omission has made another to believe a thing to be true, and on that belief, he has done something. Then, in a suit between those two persons, the person who has made that person to believe, he cannot deny the truth of this. He is stopped. That is a rule of evidence. Injunction, declaratory suit. You also fail declaratory suit, a suit when somebody's legal right, when a property or legal status is denied by another, then the person may file a suit to declare such right, to declare his status against the person who is denied. Concept based, you should, what is not necessary to answer in a lengthy manner, how your concept is clear on that. Injunction, injunction is an order of the court directing a person to do or not to do. When directing to do, that is mandatory, not to do, preventive. It may be perpetual or permanent. Temporary period, temporary. Very easy question. Dowry, your concept is also new. For the marriage, you know gender justice. What is gender neutral? It is applicable to both male and female. If a male also takes any property for marrying with him, female, then dowry prohibition act is also. You say gender neutral, but your concept is neutral. What is gender neutral? It is applicable to both gender. So dowry, if somebody only for dowry obtained from the parents of the bride or from the bride, that is not even a bride also gives some property to the groom for the marriage. That is also done. For that she is also like. So that is gender neutral. That is anyhow you take care of these things when you do not know a particular answer. Very politely you say, "Sir, I don't know. Sir, I may be excused." Never, because sometimes you have the potentiality, but you try to answer all the things. Sometimes you are committing mistake of silly mistakes. Thank you. I wish you success.
Thank you, sir.
Thank you, sir, for the detailed feedback. Yes, Madhushrava. I would also like to agree with sir on this aspect that you tried to answer all the questions. Sometimes it's okay to say, sir, I don't think I know the answer. I don't think I know the answer, or I plead ignorance for that matter. And if you respectfully do that, there will be no issue because your knowledge has been tested. I always say, interview is not where your knowledge is tested, your personality is tested here. Of course, knowledge is a part of the personality. But having said that, if you bluff in some questions, you bluffed. That I could see, like in production warrant, you had no idea. You just because from the name of it, you said that it is to produce a thing or a document.
Sir,
Okay,
actually, I got confused. Production warrant is that no, when it is sent to the jail authorities to produce a
produce
person that
the
they
person
have.
who is confined. Yes.
Yes, I got confused with the court ordering the production of documents with a
Okay. Yes.
person who have
So
power over
so
it.
maybe you know the answer and you attempted, but from the answer that you gave, it just seemed like
Yeah,
you were
I
bluffing.
actually got confused. I was not bluffing. There were two productions, and I was like, which one? That one.
Okay.
Yeah.
Then no issues. Coming to certain questions you couldn't answer. White collar crime, it's a crime. It's an economic offense when it is committed by the section of the society who is viewed as the white collar, as in the people who are the corporate class or the good class of the society. When they commit an economic crime, that's called a white collar crime. Like Nirav Modi committing a crime, or Vijay Mallya committing a crime, those are called white collar crimes. Human right, fundamental right, your concept is clear. I like that. Prescribed period of limitation. Yes, you answered it correctly that period of limitation is what is mentioned in the schedule, and prescribed period is what is computed in accordance with the act. But when I asked the follow-up question whether they can be same in a case, you said that yes, it can be same. I don't think it can be same because the section 12 clause 1 says that the first day is to be excluded. The day from which it is to be computed, it is to be excluded. So even though period of limitation is 3 years, it would always be 3 years and 1 month, 1 day for a prescribed period to be reckoned. Okay, so it can never be same. Okay, and next is whether doctrine of Cyprus. Doctrine of Cyprus is as nearly as possible. That is basically to trust and to apply trust in an equitable manner. If the entire elements of trust are not being applied, not being able to be applied, then in that case, as nearly as possible, it is applied. That's doctrine of Cyprus. Okay, it has other implications as well in personal law also. Memorandum of Association and Article of Association. Memorandum of Association is the conditions, basic conditions which are required for the company to function, and Article of Association are the detailed rules and norms which are there for the company to function. Now, amendment after trial, that you gave the correct answer. Hicklin's test. Hicklin's test, it is a test to determine the obscenity. It came into picture when the Ranveer Singh issue came into the picture. Then it was determined that Hicklin's test says that if it is applicable to the larger section of the society, then according to the Hicklin test, that is obscene. If it is not applicable to the larger section, then in that case, that's not obscene. Attempt and preparation, I liked your answer, the way you use the potential test along with that proximity for that matter, that was quite appreciable. Yes, effect of delay in holding pirate, that was also good. Production warrant, as you could answer now, yes, it is to produce a particular person who is detained in a prison. And yes, whether a warrant case can be converted to a summons case, no, but summons case can be converted to a warrant case. Father of CPC, he is Arthur Hobhouse. Arthur Hobhouse is called the father of CPC. Okay. And constitution versus constitutionalism. Constitution is the text, whereas the constitutionalism is the spirit behind that text. Spirit behind that text, which is there, that is called constitutionalism. Okay. And then, what is the issue with the Citizenship Amendment Bill? The issue is that all other religions immigrants were allowed citizenships, excluding the Muslims. That's why it was said that why not illegal immigrants having Muslim religion, they will not also be allowed. That was the fuss about. Okay. So these are the questions that you could not answer, but yes, I believe that you have a fair chance because I see potential in you. I see that your conceptual clarity is there, barring the thing that, yes, of course, there will be questions like that to throw you off here and there. There can be questions like that. So you don't have to really fudge like that. Like oh yes, the question that I asked, whether criminal courts have inherent power. To that effect, 482 says that nothing contained in this CRPC would limit the inherent powers of the High Court. That means the inherent powers of the High Court are unlimited. That is not limited by CRPC. But it never says that magistrate does not have inherent power. It just says that if CRPC says something, then the magistrate cannot choose not to go in that manner and do something of its own. That is what it means, 482. But of course, if CRPC is silent about it, silent about something, here magistrate if wants to use his inherent power to do justice, that should not stop it. That should not stop it. 482 cannot come in its way. Are you getting it? So that is what I wanted to hear from you. Of course, this is a very complicated concept, but the fact that you could appreciate it is appreciable, in fact. Okay, so I see that you have potential, and I'll definitely say that you are one of the few candidates who is likely to clear the exam this time. And having said that, don't be complacent. Just revise all the subjects once more and try not to answer any question if you do not know. Of course, I probably could not get to know you better. That's the reason I couldn't know whether you are bluffing or not. But yes, I just got that impression because of the every answer that you gave. So try avoiding that. All the answers that you know it, stick to them. And if you don't know it, politely say, sir, I plead ignorance. I'm not aware of this, or I know this, I'm not able to recollect right now. Also, one thing I wanted to add to your way, the way you give the interview is, with every question, when the question ends, you may start the answer like sir and then give the answer. Or the better way to is, sir, thank you for the question, and then to that you'll answer. So it cannot be impromptu, just the answer to the question that is being asked. At least address the board. At least, sir, one word of sir, that will also suffice, but that has to be there. Directly coming to the question, that kind of throws it off. Okay. So that's all. You're smart enough. I see you pulling it off this time. That's all. Thank you.
Sir, I had a question actually, if you
Yes.
don't mind.
Yes.
Sir, I saw your message in the group that we should not like say our name in the introduction.
Yes.
So if they ask us to introduce ourselves, should we just say
Then
that
you skip your name. Other than that, other things that you mentioned in the introduction, that you can. I am from this place, and I have done my law from this place. That's all you can say. But don't mention your name. That is the strict rule of OPSC. You cannot mention your name
Okay.
wrongly also in the interview. Here in the mock, you are mentioning, we are calling you by name, that is fine. But they do not know your name. There also, the panel does not know your name. So they'll miss candidate or something, or miss, they will address you like that. Okay, so that's all.
Okay.
Hello,
Okay, sir.
Madhusrava. So for UCC, Uniform Civil Code, your answer should be, it will bring unity and integrity of the nation. That is only question. Why you are joining judicial service? It is a secure, prestigious, and independent service. This much. Never say any other thing. Why you are
Yes,
interested?
yes. That is important. Sir has pointed out that you don't mention that my family member is a judicial officer or anything. Okay,
Oh, okay.
that will
You
also
simply say like
badly.
this.
Sorry,
Simply
sir?
because your answer should be, it is a prestigious, independent, and secure service. So that's why I intend to join judicial.
Okay, sir. Thank you, sir.
Okay, and I probably can add that I want to make a meaningful contribution to the society by joining this
But
prestigious.
then, sir, you asked me why not litigation. So if I say that, it will be like advocates are not doing a meaningful.
But I think that
thing.
my standards or my qualities ask me to, I mean, but require me to join this service because I think I'm better suitable this way. There also, yes, I can serve the society, but my qualities point to the fact that I can serve the society better in this. That's all. That can be a counter.
Okay.
Okay.
Okay, sir.
Okay. Thank you, Madhushrava. All the
Thank you.
best.
Thank you, sir.